I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes.
Karen Reed's 2.5-month trial ended with those famous words by Norfolk County Superior Court Judge Beverly Cannone. Now Karen Reed's attorneys are telling the Massachusetts Supreme Judicial Court, take a look at that video.
Would a normal person have thought things would have just ended at the mistrial? That's not how things are panning out. I'm Lainey Law.
And I'm attorney Andrew Myers.
And it seems like ever since the mistrial was declared, things have just gotten crazier and crazier. You thought that with the trial all settled, maybe things would, settle down a little bit, but it just seems like more and more news and more information about this case just keeps popping out.
Yeah, and now Karen Reed's attorneys have filed a brief with the Massachusetts Supreme Judicial Court. We covered it when they filed their initial petition and then their memorandum. And then to be fair, we covered the state's objection or the state's response. And now the last thing that's filed before the hearing in November is the reply brief by Karen Reed's attorneys. So we're going to do that. But also, there are some new developments in Duckgate, so hang with us. We're going to cover the new developments actually in court. When have you ever heard of rubber ducks going to court? Well, it happened in Massachusetts. And the other thing we're going to look at this week is one of the top Massachusetts State Police troopers supervising the people involved in the prosecution of Karen Reed kicked out of Norfolk County. So the first thing we're going to do is take a look at the reply brief of appellant Karen Reed. This has been filed. This is the last document that gets filed before the Massachusetts Supreme Judicial Court actually takes a look and has oral arguments. And there are the attorneys that represent her, Martin Weinberg, Michael Pabian. There are people that say, oh, well, Alan Jackson's out of the case. No, he's not out of the case. There's his name right there. He is on this brief that has just been filed, pro hoc vice, meaning a Latin term, one of the few Latin terms that's left in our law, meaning that he's not a member of the Massachusetts bar. He is a member of the California bar, but he is allowed to appear pro hoc vice. That means that he is given full status in the case. And David Yannetti from Boston. So as always, there's a table of authorities. Those are all the cases that Karen Reed's attorneys are relying upon. Of course, the Fifth and Sixth Amendments, a bunch of statutes and rules. Ms. Reed's motion to dismiss is predicated upon post-trial statements of 5 jurors. Remember that? Juror A, B, C, D, and E, that the jury reached a final unanimous decision to acquit her of second-degree murder. In the usual course, that verdict would have been announced in open court, and re-prosecution for that charge would be constitutionally prohibited. Here, however, the court failed to inquire pursuant to Mass Rules of Criminal Procedure 27B. And we went over this right after the mistrial was declared regarding the existence of any partial verdicts. And for that reason, the jury acquittal was not announced. The Commonwealth's argument that this court should defer to the trial judge regarding the necessity of a mistrial seeks to inappropriately bypass the clear prerequisites that have been in place for almost 4 decades, that before the declaration of a mistrial, 1, counsel must be given a full opportunity to be heard, and 2, the trial judge must give careful consideration to alternatives to a mistrial. We're going to take a closer look at that coming up. We're going to jump to the really important material in this reply brief. Nothing in the Commonwealth's brief, according to the attorneys for Karen Reed, justifies the trial court's failure to consider the alternative of inquiring regarding the existence of any partial verdicts pursuant to Rule 27B. While the timing of whether to accept a partial verdict is ordinarily discretionary, Rule 27B requires the trial court to accept such partial verdicts before declaring a mistrial. See, now here they're going beyond the rule, and anytime, and I wish I had one of my rule books to show you, anytime there's a rule, below the rule is reporters' notes, notes of the people that wrote the rule. And what the appeal attorneys for Karen Brief are saying is this rule provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict. However, it must, notice the emphasis, it must first receive and record the verdicts, which the jury can agree upon.
That seems like a pretty open and shut case right there, though.
It does. It does. And we talked about Rule 27 earlier in another episode. It did seem that the language of the rule was discretionary, saying that the court could inquire. But a lot of us, unlike the appeals attorney, and that's their job, did their research and came up with this mandatory language in the reporter's notes. So they base their analysis on a lot of case law, which we're going to skip over and just tell you the crux of the argument, because I think that's all that people really, really, really want to know. The trial court's failure to consider inquiry regarding partial verdicts cannot be excused based on speculation that defense counsel may have objected to such inquiry when, in fact, defense counsel never did. The court could and should have raised the issue with the parties and considered their respective views. This is precisely what the two-pronged test in two cases that they indicate requires. Defense counsel's earlier argument regarding the propriety of the count two verdict form, which the trial court ultimately agreed with, did not excuse the judge from complying with this court's manifest necessity jurisprudence. Video footage. Remember in the opening we showed you a little video clip? Video footage. Look at the little footnote there. They tell the court, we want you to watch this. And the clip that we just showed you, is, you click on that link, it'll take you right to it. So remember in the opening I said they're telling the Supreme Court, the Supreme Judicial Court of Massachusetts, take a look at this. Video footage reinforces the suddenness of the court's action and corresponding lack of any meaningful opportunity to be heard. At approximately 5 hours, 47 minutes, 25-second mark of the video, the court took the bench and stated the jury is at impasse. At approximately 5:47:55, a mere 30 seconds later, the jury arrived in the courtroom. The court then read the note, which had not previously been provided or read to counsel on the record. At 5:49:23, the court stated it was declaring a mistrial and immediately discharged the jury at 5:49:30. A mere 7 seconds later, to suggest that counsel must have lodged an objection within this brief interval, or that counsel had any, much less a full opportunity to take a position or even communicate with their client, underestimates or ignores the difficulty of reaching a decision in which the defendant has an evident personal stake, whether the defense would be advantaged or the opposite by a second trial. So remember we talked about this summer, right after it happened. The Commonwealth is kind of saying, well, the defense never objected after the jury note was read. The defense never objected, but they didn't have a chance.
I love that it had the full receipts. It was just like, here's on this video at this timetable, timetable down to the seconds. It's like, as you can see here, there was no opportunity to reply, which I think this is done really well. And it's like funny to see like a YouTube video and like timestamps being used
in a Supreme Judicial Court brief.
But I also feel like, especially with the way this world is going, I feel like this is going to become more and more common because like, think about how many people film every second of their lives and are posting it online. Even with the Sarah Boone video, for example, it's just like you see evidence over here at 5 minutes and 30 seconds. It's like now that everything's on video, it's interesting to see how this is gonna impact law to be able to say that.
So with that issue in mind, the Commonwealth said that the defense never objected. Once the jury note was read, the mistrial was declared immediately with no opportunity for the attorneys to object. Let's take a look at that video right now. In the background there is Paul O'Keefe, that's John O'Keefe's brother, the brown shirt. And in the back, in the green polo shirt, that's Turtle Boy. That is Mr. Aiden Kearney, Turtleboy, hiding behind our logo. The jury is coming in. They all stood. You always stand.
All right, Mr. Foreman, I am in receipt of your note. Judge Cannone, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case. I'll be in to see you privately in a few minutes. So thank you so much for your service. Okay.
All rise for the court, please.
And there's Yannetti and Karen Reed and Alan Jackson, all kind of. So, you know, they didn't have a chance. They did not have a chance. The jury note was read. We would have to compromise our principles. I'm not going to do that to you, the judge said. I'm declaring a mistrial. She didn't even take a breath, really, between reading the note and then declaring that mistrial. So, you know, I mean, the link to that video is down in the Supreme Judicial Court's notes. And don't you think that they will actually take a look at that? I do.
Yeah, I think it's really interesting that they have everything on file now. I mean, it's going to be hard to fight with that, you know, like fight against that.
Well, anybody can watch YouTube, right?
Yeah.
We've proven that.
It's free with an internet connection.
So I would think that the argument that had been made by the state that, well, you know, earlier when the notes were read, they opposed the Tui Rodriguez instruction, or they were for it, and they, you know, none of that's relevant, in my view. None of that is relevant at all. The only thing that's relevant is that where the law says that defense counsel should be consulted and be given the opportunity to have some input, they weren't. And if you're in court, let me tell you this. If you're in court and a judge is talking, you don't interrupt the judge. Let me just tell you that, because if you interrupt the judge, it's not going to be a good day for you.
The bailiff grabs you and chucks you out by your shirt and pants.
Well, I've never had that happen to me, but, you know, I mean, early on, I recall interrupting a judge a couple of times, and the day didn't go too well for me. I mean, you learn that right away. And these are experienced attorneys that have been doing it for an awful long time. So they know better. They know better than say, Judge Cannone, wait a minute.
Nah,
you know.
Hold, please.
So the court, according to Karen Reed's attorneys, are saying that the court should reject the Commonwealth's attempt to conflate a request for a Tui Rodriguez charge with a request for a mistrial. They're two different things. As the Commonwealth acknowledges, a Tui Rodriguez charge is designed to encourage a jury to consider seriously and with an open mind the views and arguments of each member, with the ultimate goal of reaching a verdict. So to confuse one with the other is not a good day for the Commonwealth, in my view. The Commonwealth's contention that Ms. Reed consented to the mistrial is based on the unsupported assertion that defense counsel consistently sought a mistrial. So as we just saw in the video, you know, they were not given a chance. The next major point that Karen Reed's attorneys do make in this brief is that the jury's unanimous conclusion following trial that Ms. Reed is not guilty on counts 1 and 3 constitutes an acquittal and precludes reprosecution. For more than a century, binding case law has warned against the elevation of form over substance in determining what constitutes an acquittal for double jeopardy. There's a seminal United States Supreme Court case. However, it may be in England. In this country, a verdict of acquittal, although not followed by any judgment, is a bar to a subsequent prosecution for the same offense. While many of these cases have arisen in the context of judicial acquittals, the Commonwealth does not explain why form should outweigh substance with respect to jury acquittals. Remember, we've said in the past that we think that the Commonwealth might have a good argument because they're saying, the only verdict is one that's read out loud in court. That's what the Commonwealth is saying.
Mm-hmm.
The third major point that they're making in this reply brief is that Karen Reed, the defense, is entitled to a judicial inquiry to determine whether the evidence supports the juror representations as to having acquitted Ms. Reed. And this is a subject that we pointed out. The ACLU filed an amicus curiae brief saying, guys, just bring the juries back. And as you pointed out, with all the technology we have, why even make them come physically to the courtroom? Why can't they do it electronically?
Have them send a text. I mean, obviously not a text, but it's just like call in, use a phone, use a Zoom.
Yeah, why not? The Commonwealth, in opposing the defense request for a post-verdict judicial inquiry to substantiate the acquittals, takes a striking position. Under the Commonwealth's logic, I think their thinking or lack thereof, but that's just me interjecting that. Strike that. No defendant claiming that the jury acquitted her but failed to announce that the verdict would be entitled to further inquiry, no matter how clear and well supported her claim. In other words, even if all 12 jurors submitted affidavits saying they unanimously and finally agreed to acquit the defendant, their failure to announce that verdict and the trial court's failure to follow Rule 27B would take precedence over the defendant's fundamental constitutional protection against double jeopardy. The Commonwealth's position is not required by any precedent of this court and is insufficiently protective of the defendant's rights. The court should reject this inflexible rule as achieving stability at the expense of doing justice between the parties. As noted in the defense opening brief, this court and others have permitted post-verdict inquiry regarding claims of extraneous influence and juror bias. So why, this is me saying it, why shouldn't they do it in this situation?
Mm-hmm.
In Rummer versus the United States, a 1954 case, the United States Supreme Court held that the defendant was entitled to post-verdict inquiry regarding the FBI's unauthorized contact with jurors. Much like in the context of juror bias or untruthfulness, and now they cite a 2020 case, courts regularly follow Remmer and hold post-verdict inquiries when there is a reasonable basis to support a claim of external influence. So again, they're making the argument that's different. People will tell us down in the comments, I'm sure that's different. It's different, but it's without a distinction because there's a serious issue in this case as to whether the fundamental right against double jeopardy is being infringed upon in this case. And they conclude, as I've said before, our About the Law channel, when you go to court, you always want to be very clear and leave no doubts as to what it is that you want. So in conclusion, in the reply brief, they are saying, for the foregoing reasons and those set forth in her opening brief, Ms. Reed respectfully requests that this honorable court reverse the trial court and order counts 1 and 3 dismissed.
I feel like that's asking a lot. Like, I feel like we should just be starting with, can we just call them on a Zoom call instead of dismissing the cases? Because you don't even know what's going to happen.
Well, they want that too.
They want all of it.
Yeah, they do. And again, people have said, well, Alan Jackson's out of it. No, he's not. Here he is as one of, we sign things electronically these days. He's one of the 4 attorneys that signed this reply brief in the Massachusetts Supreme Judicial Court as recently as October 23rd. So, folks, he's still in the case. And I don't know. I thought that was interesting. We promised that we would read everything. We read the first petition, the first memorandum, the Commonwealth's memorandum, and now the reply brief. So all the pleadings are in. Now it's to the procedure is that the Supreme Judicial Court reads it all, And I know they do because I've been there. And if you're not familiar with every word of your brief, that's what they're going to ask you about. And so they will read it. Maybe their clerks read it and summarize it for them, but they know every word of it. And after they digest all of the paperwork, and I bet you anything they'll watch that video. Don't you think they'll watch that video? And then they will call the attorneys in. There will be oral arguments, and all this will be done, I believe, by the end of the year. The hearings for oral arguments will be done in November. That'll give them, 6 weeks to the end of the year, New Year's. And I would think that the people that are trying this case would want to know by then because, to get ready for a trial on January 27th, there were 74 witnesses in trial 1. So who knows how many witnesses will be in trial 2. They've already got new witnesses. We did that in a previous episode.
I don't know. The whole thing is crazy. The fact that they're trying to pack everything in these next few months, but obviously we're not going to see what happens next year potentially based on what happens in November. So
yeah, there's a lot going on behind the scenes. Remember all the Massachusetts state police officers that testified, and we had lead detective Proctor making some not very nice comments about Karen Reed. Remember all that? Well, now we have Mr. Tully, who was like a supervisor. He's been kicked out of Norfolk County. He testified. Here is Lieutenant Tully testifying in the Karen Reed case. This headline comes to us from the Boston Herald. Karen Reed case. Massachusetts State Police remove Lieutenant Brian Tully as chief of the Norfolk County Detective Unit. And there he is testifying in the Karen Reed trial. I believe they give the date here. Yeah. Mass State Police Detective Lieutenant Brian Tully on the witness stand. The Karen Reed murder trial in Norfolk Superior Court, Dedham, Massachusetts on Wednesday, June 12th of 2024. Remember this? The court was hot. It was getting hot. It was a hot summer. And the judge would say, speak up or I'm going to turn the air conditioner off.
Yeah.
Anyhow, article by a good reporter, Flint McCoglin. The Massachusetts police have removed Detective Lieutenant Brian Tully as the head of the Detective Bureau, posted at the Norfolk DA's office, and is ready to hire someone else for the job. The Mass State Police's new leader, Colonel Jeffrey Noble, quote, has conducted an initial review and believes this decision is in the best interest of the department's public safety mission, according to a statement by MSP spokesman Tim McGurk. Tully and two of his underlings, Sergeant Yuri Buchanan and Trooper Michael Proctor, who served as the case officer of the investigation, took the stand in the Karen Reed murder case, which was declared a mistrial, as we know from all the stuff we just read. They were each subsequently put under internal review. Tully and Proctor remain under investigation, with Proctor currently out of work, but not quite fired. Buchanan was forced to forfeit 5 days of accrued leave, but is still working.
Not my 5 days.
Yeah, that's like, I don't know. It's like sending a little kid to his room when he has his iPod and his iPad and his music and probably a bag of Doritos up in his room.
It's like a in-school suspension where your parents don't even know you're suspended and you just go to school and you have to not go to class for a few days.
Yeah, you sit in the study hall.
Mm-hmm.
Yeah, and you talk to the girls or you talk to the boys. Mm-hmm. Anyhow, while Buchanan was the first of the trio to testify. See, I know all about what bad kids have to go through at school. I remember it quite well. Anyway, while Buchanan was the first of the trio to testify, it was Proctor's testimony that blew up. He admitted on the stand to using, quote, regrettable and unprofessional comments, unquote, in talking about Reed in texts to friends and co-workers, including calling her, quote, a babe and a, quote, whack job, and hoping that she kills herself, and a lot worse, which we're not going to go over again as we have in the past. In a Friday night police statement, a spokesman confirmed that Tully has been moved to a temporary assignment in the MSP Division of Investigative Services, but will be available to assist with any cases in the Karen Reed matter. I think that our little PDF printer cut off a couple of words, but that's what it said. Tully headed the detective bureau stationed at the Norfolk District Attorney's Office during the investigation into the death of Boston police officer John O'Keefe. Lieutenant Tully was also involved in the Norfolk County District Attorney's Office's investigation in the Sandra Birchmore case. Remember that one? The one that the Norfolk County District Attorney's Office kind of said, walked away from it and waited, 2.5 years until the feds indicted Matthew Farwell for the M of a witness and a victim. So, these guys that I'm not going to say these guys that blew it in the Sandra Birchmore case also blew it in the Karen Reed case.
Mm-hmm. I mean, it's scary. You don't want to live in a town where you have to wonder whether or not you're safe around the police. I think a lot of people, we hear a lot of horror stories and we already have some apprehensions because you never know how the interaction's going to go. It's just anytime you really hear about a police interaction, it's your friend saying they got a ticket from a D-bag cop or whatever. I guess your experience is a little different because it's usually the cop saying, Attorney Myers, we have your client here. But I definitely, I don't know. It sucks. It sucks that this is happening. It sucks that we have to hear more about this because obviously you want to believe that we're safe, but it's hard to feel safe when you're reading about situations like this.
Well, it's not just the town of Canton, as bad as things are there. It's the entire Norfolk County, which is a huge county. It stretches from Brookline, which is just outside of Boston, all the way out to Metro West. It's a huge, huge, huge county. But it also affects the entire state because they shuffle these MSP troopers around. And, so it's really the whole state. The investigation, of course, was a target of Reed's defense, which claims that Reed was framed by a massive police and prosecution cover-up. The chief of the office, and that's what Tully was, and now they're going to bring somebody else in. The chief of the office oversees about 20 troopers tasked with investigating all kinds of different crimes, including narcotics, organized crime, financial crimes, and all kinds of other stuff. So, the ramifications of this are just, and I don't see how they're going to try the case. With Tully gone, with Buchanan having had his hand slapped, Proctor's been suspended without pay. The final shoe hasn't dropped on his case. But with all of that going on, I just don't see how they're going to try the case because all of that's fair impeachment material. Mm-hmm. All of that is fair impeachment material. In other words, they can bring Buchanan, they can bring Tully, they can bring Proctor for the rerun of the trial. It's hard for me to imagine, the 2.5 month trial. But anyhow, they can bring them all in, but it's fair impeachment to say, hey, weren't you kicked off the job for in part for conduct during this investigation? And the jury, I would think, would be scratching their head saying, why are they trying this case?
Mm-hmm.
I digress.
That's the main thing where it's just how are you going to try a case when you have all these officers that were involved in the case and they're having all these legal issues?
I don't know. You didn't bring in the ducks. Remember we had the ducks? We had the ducks.
No duck displays today.
Do you want an update on Duckgate?
Dun, dun, dun. What's going on in Duck World today?
There was actually a hearing this week in Stoughton District Court. Stoughton being right next door to Canton. I hope our viewers can read this. It's kind of small.
I think they got it.
There we go. Duck Man Goose. I love the Boston Herald. They come up with these headlines. But actually, the article itself was written by the Associated Press. So whether you like the Herald or not, this was written by the Associated Press. The Karen Reed murder case has inspired crowds of pink-clad supporters dividing the town of Canton and providing juicy content for true crime podcasters. Hey, leave us alone. Now rubber ducks are in the mix. On Wednesday, one of Reed's ardent supporters pleaded not guilty to intimidating witnesses, harassment, and littering. Richard Schiffer Jr. admits that he's been placing dozens of yellow rubber ducks and fake $100 bills around town, but says he's got a First Amendment right to support the defense theory that Reed has been framed in the polarizing murder case. Hey, do you remember when we talked about Duckgate a few weeks ago? I said, those little stones, those stones that people leave around, right? People paint these stones and they say peace or love, or they paint a flower, and it's all, good. I saw a picture in one of the newspapers of ducks painted on these little stones.
Actually, I was just thinking that I feel like it does make sense for freedom of speech, because it's kind of like a peaceful protest.
So like if I paint yellow rubber ducks on a stone and leave that out, am I littering?
You're going to be charged with felony charges at that point, Andrew. This is the only logical solution to this.
I hope that oh boy. So we're going to skip that paragraph because it just gives the background of on the Reed case, which all of our viewers know all about. So we're going to jump here to where it points out that the 65-year-old Schiffer didn't speak during his brief appearance in the Stoughton, Massachusetts District Court, but greeted several dozen supporters outside. Several wore T-shirts emblazoned with rubber ducks, while some carried American flags or placards supporting Reed. One woman brought her pet parrot, who was wearing a cape with the words "quack, quack," while another person had a huge flag with the words, "Are they ducking crazy?" Now, I went online, I went into the image searches and tried to find a picture of this parrot. How do you get a cape even on a parrot? So I tried to find that image. I couldn't find it. If any of our fine viewers have an image of that, send it to us and we'll put it in one of our future podcasts. So Mr. Schiffer said, "I'm overwhelmed by the support from everybody," Schiffer said. Before opening a bag someone handed him, it contained a silver duck. "When I did this, I didn't think it would go this far," he said to shouts of "We love you." Schiffer has said he got the duck's idea after thinking about defense lawyers' closing argument that Reed was framed. Alan Jackson, as we know, told jurors that if it walks like a duck and talks like a duck, it's a duck. The police report, remember the 36-page police report, also mentioned the connection between Jackson's comments and the ducks.
No.
No. That's crazy. That's nuts. So, where was I? Okay, here we go. Schiffer's attorney, Timothy Bradle, said he would move to have the charges dismissed on First Amendment grounds before their next court date in November. So there he is. There's the man behind Duckgate. That's him, Richard. Wait a minute. I gotta restate that. That's the man who's allegedly behind Duckgate, Richard Schiffer Jr., who faces witness intimidation and other charges related to the Karen Reed case, holds a duck as he greets supporters on the steps outside of the Stoughton District Court following his arraignment on Wednesday in Stoughton. Oh boy, a long time ago I went down to Stoughton District Court. This is what our country is all about, assembling on the courthouse steps, speaking out against ridiculous government overreach, the attorney told the crowd. What is going on here is viewpoint discrimination. They don't like the message. The Canton cops don't like the message. They should be embarrassed. There's no crime here. The defense alleged that O'Keefe was actually killed inside the home of his fellow Boston officer, Brian Albert, and then dragged outside. They argued that investigators focused on Reed because she was a convenient outsider who saved them from having to consider law enforcement officers as suspects. Schiffer, who owns Canton Fence, that's the name of his company, and has said that he knows practically everyone in town through his contracting work, is accused of placing some of the ducks outside a pizza shop run by Brian Albert's brother, Canton Selectman Chris Albert. Other ducks appeared in the O'Keefe neighborhood. Okay. So.
No, the duck situation is out of control. What are we going to do with all these menacing ducks everywhere?
No, I can't see them taking that case any further. I mean, I don't know. I've handled district court level cases over the years. I've never handled a littering by duck case. And is it really intimidation of a witness? I mean, now we've had comments down below, and I've heard elsewhere. If you listen to the Howie Carr show, Mr. Aidan Kearney, Turtle Boy himself, has been talking on there and how he has been talking about the fact that right after the trial, containers, balloons filled with bleach were left on the front lawns of some of Karen Reed's supporters. And to me, a balloon filled with bleach is a lot worse than a little rubber duck. I mean, a little rubber duck is a joke. We had them in here. We had them on our microphones. It's like it's a joke. I mean, get over it. I mean, so I don't know. And there was a 36-page police report on it too. So, I mean, it's a little bit ridiculous. We started out serious reading the Supreme Judicial Court legal brief citing United States Supreme Court cases, and we end on the Duckgate update. But it's obviously not over, because what's going to happen in the next Duckgate hearing?
The whole idea that we're having all the Duckgate hearings is kind of sad, because when you think about it too, it's like, how many things are people actually getting away with? It's like actual crimes happening. It's like no big deal, but rubber ducks, and now we're in this mess. It sounds a little crazy.
And I'll probably regret making this next statement. But having said that, I now have to make it, and that is that the courts are constantly telling us that they're overcrowded and overburdened, and the caseload is too much, and they need more staff, and they need more money, and they need more judges. And I agree with all of that, because I've been in the courts and had to sit there, for a long period of time until my case gets called, and then, cases get put off for a long period of time. So I know I will regret saying this, but if the courts are so overburdened and overcrowded, what are they doing, litigating, ducky cases? You know what I'm saying?
I completely see and agree with that. I think that there's a lot of resources being used for things like this, and it's
and the district courts in Massachusetts
Yeah.
are very busy courts. They're very, very, very busy. The Boston Municipal Court and then the district courts in all of the other counties around the state handle a lot of stuff. They handle, all crimes up to felonies, which is, drunk driving and assault and battery and car accidents. And on the civil side, while they're battling out all of this criminal stuff, they're also, dealing with all of the personal injury cases, cases that I'm involved with mostly. And the courts are busy. You can go to any court, Stoughton, Lawrence, Worcester, anywhere. And on a Monday morning, you're going to sit there and wait all morning because they are busy. So I don't know.
It's like the DMV almost.
The what?
The DMV of courts.
Yeah. It's worse than that. It's worse than the DMV. It's just, you sit and you wait and you sit and you wait and you sit and you wait. And you find that you can't sit and wait anymore. So you take a break, and that's when your case gets called. So. Fortunately, if the court clerks know you, they'll page you and say, attorney so-and-so, get back in here. So I don't know. I don't know what is going to happen with this. I mean, I don't know if they will recommend a plea. Many, many, many cases end with a plea bargain. But I mean, if I were accused of, witness tampering, littering, and the witness intimidation, littering, and what was the other charge? If I was accused of all those things, I wouldn't want that on my record.
Mm-hmm. Yeah, that's a quick way to ruin someone's life forever, it seems like. Which may be the intention, yeah.
He's 65, but still, these days I see that as pretty young.
Mm-hmm.
And I wouldn't want it on my record at any age. And if he's like me, a local business guy, I don't have any record. I'm sure he doesn't have any record. So I wouldn't think. No, I don't know. Duckgate continues, and we'll have more updates not only on Duckgate, but also on the Supreme Judicial Court's litigation of the appeal as to whether or not they will order the Supreme Court. I'm sorry, whether or not they will order the Superior Court to bring the jurors back. It seems like this is something that's happening more and more. Crazy things happening with jurors, and it happened in the Murdoch case. There are issues with the Ashley Benefield, our favorite episode. There's a question about what happened with the jurors in that case. So it's happening more and more, and I'm thinking that it's going to make people less and less inclined to even want to be jurors. I don't know.
No, yeah, I definitely understand that perspective. It's hard. It's frustrating to see situations like this where it just seems like a big waste of time, and that it's out to just hurt the people. you know.
The only little issue as a closing thought that kind of makes me wonder is that, right after the murder trial, 3 of the jurors ended up on Good Morning America. I haven't seen that any of the Reed jurors have come out publicly. Yes, they've called the lawyers. Yes, they've submitted affidavits. Yes, they've called a few podcasters, and made a few statements, but they really haven't seriously publicly come out and talked about their experiences. And I'm not taking anything away from Reed's attorney's briefs and the jurors A, B, C, D, and E. But what about F, G, H, I, J, K, and L? What about the other ones? We haven't heard from them. So anyhow, that's my closing thought. What's yours?
Yeah, and I think you made a good point with your closing thought, which is like we haven't even heard from anybody else. It's just like at the end of the day, it's just one Zoom call, like because you never even know like what they're gonna say. But I think it's better to be safe than sorry, and I appreciate everything everybody has to say down in the comments below. We appreciate you guys watching until the end.
Yep. Be sure to comment, like, subscribe, do all those other great things, and until next time.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.